So, counsel, if I understand, I'm sorry. Go ahead. All right. If I understand, I just want to make sure I've got the points of difference between you and the government. One is circuit foreclosure, in your view, as opposed to Supreme Court foreclosure on the government's view.
Yes, Your Honor.
Second is actual innocence versus maybe something more than actual innocence required. And third is, I think, that you take the position that absent adopting some form of relief here, there would be serious constitutional questions raised by the statute, and the government doesn't believe so. Is that a fair summary?
That's a fair summary, Your Honor.
Okay. And then with respect to what the Savings Clause would do on the amicus's reading, you argue it would do too little work, but it was adopted first in 1948, and it was done so when habeas was shifted primarily from the sentencing court to the court of confinement. And for at least 50 years, the only purpose of that statute was to ensure that if the sentencing court was unavailable, court martials, the sentencing court, you couldn't transfer the prisoner for whatever reason, natural disasters or other COVID problems perhaps, that there would be some court available. And so I guess I'm unclear why, after 50 years, we would expect the Savings Clause to do a great deal of new work.
Well, first, Your Honor, it wasn't doing some of the work that you and the Court of the Court appointed amicus have identified. It does not cover.
It did in the 10th Circuit. I know that. I remember that.
Well, Your Honor, this court itself, in the Ortiz case, very recently declared that court martials pre-existed the Constitution, let alone an act of Congress. They were not established by an act of Congress. They were recognized by Congress. The court martial is evanescent. It disappears. There is no court to go back to. And so, at least in 10th Circuit, and I believe in a lot of other courts, in those cases, the court of confinement was made available because there was no sentencing court to go back to. So that was one example. And natural disasters was another example. Are you aware of any others during the 50-year period between 1948, well, not 50 years, but almost 50 years, between 1948 and 1995? Well, if I may just for a moment push back a little bit on that. Of course. I'm sorry. But of course, court-martial, traditional habeas relief was available for court-martials, but it was not made available through 2255E.
No, of course, but that did make it, 2255E was cited as an authority to send those cases to the 2241 court.
And usually not, Your Honor. Maybe in the 10th Circuit it mistakenly was, but they're not authorized.
Mistakenly?
Well, they're not. Court-martial, 2255 only authorizes people to pursue 2255A authorizes people to pursue motions to vacate under 2255 only when they're under sentence by a court established by an act of Congress. And court martials are not established. So,
okay.
2255
so you're saying that wasn't even available during the 50 years.
Right.
Okay. So what was it used for during those 50 years?
Well, there are two cases we've been able to identify. One was where a case was transferred from the, when there was a conviction from the Court of Appeals for the from the Court of the Panama Canal. And another was when some courts were transferred to the state courts of Alaska after Alaska became a state.
Okay.
And the state courts refused.
Fine. Well, whatever the examples are, they were very limited, you'd agree.
For sure, but that doesn't indicate, Your Honor, what Congress intended the scope of the Savings Clause to be. The Savings Clause, as this court itself described in Hammond and a decade and a half later in Presley, was meant to serve as a kind of constitutional backstop so there would never be any constitutional doubt about the adequacy of 2255. And so as Congress originally intended in 1948, that as the contours of Section 2255 changed, it would never be placed under constitutional pressure because 2255 would always allow this out.
All right, so that takes us back to the constitutional disagreement you have with the government, though, right?
About whether only over the constitutional
whether the scheme
doubt
is required for constitutional purposes that you're advocating.
Well, that was only one purpose for the Savings Clause, Your Honor. The other purpose that the court identified in Hammond, and I believe in Presley as well, was to prove that it was make sure that habeas overall, either through 2255 or 2241, provided an adequate remedy.
Can I test that proposition just for a moment? So you speak of it, the necessity for an adequate and effective alternative, and you suggest if there's circuit foreclosure, then it isn't an adequate or effective alternative. But when we speak of adequacy and effectiveness in, for example, ineffective assistance claims, we use those very terms. And we often find, and these are often habeas cases, that counsel was effective even if he lost. So why should a victory be equivalent to effectiveness?
Well, I'm sorry, Your Honor. I must have misexplained or inadequately explained things in our briefing. We do not claim that an adequate remedy guarantees a prisoner's victory. We believe that it guarantees that the correct law be applied to his case at least once. And that has not been the case here.
Okay, thank you.
And that's not been possible.